Good afternoon. My name is Brian Lowe and I represent Roll-A-Fun Seashore Amusement Parks Limited in this challenge to the London Centre for International Arbitration Court to have the appointment of Dr. Gagarin as arbitrator in the matter of an arbitration between Roll-A-Fun Seashore Amusement Parks Limited and Jarndyce and Jarndyce DUO revoked. Article 5.3 of the LCIA rules state that all arbitrators shall be and shall remain at all times impartial and independent of the parties. Article 5.4 of said rules requires any arbitral candidate to sign a written declaration stating whether there are any circumstances currently known to the candidate which are likely to give rise in the mind of any party to any justifiable doubts as to his or her independence, and if so, specifying in full such circumstances in the declaration. In his declaration, Dr. Gagarin did not identify any such circumstances. However, subsequently it has come to light that there are circumstances which the claimant believes give rise to justifiable doubts as to his independence. These circumstances are: 1. Dr. Gagarin worked together with one of the lawyers representing the respondent on a case a year ago and in fact received a laudatory recommendation from that lawyer on LinkedIn. 2. Dr. Gagarin once got into a drunken skirmish with a Mr. Howie, who is a member of the board of directors of an affiliated company to the claimant. 3. Dr. Gagarin has in the past authored an article advocating a relaxed approach to performance of contracts in the amusement industry. These circumstances are sufficient to cast justifiable doubt upon the arbitrator's ability to act at all times impartially and independently as required by Article 5.1, and the Court is requested to revoke the arbitrator's appointment as provided for under Article 10.1 of the LCIA rules. In support of its challenge, the claimant relies upon the case of R.V. Goff, 1993 AC 646, where Lord Goff of Chieveley stated at page 160, having ascertained the relevant circumstances, the court should ask itself whether, having regard to those circumstances, there was a real danger of bias on the part of the relevant member of the tribunal in question, in the sense that he might unfairly regard, or have unfairly regarded, with favour or disfavour, the case of a party to the issue under consideration by him. It is submitted that given the aforementioned circumstances, which have only recently come to light, there is a real danger of bias on the part of the arbitrator in the sense as stated. In addition to this, in the case of Porter v. McGill, 2002 2 AC 357, Lord Hope at paragraph 103 expressed a modest adjustment to the impartiality test in R.V. Goff and stated that the question is whether a fair-minded and informed observer, having considered the facts, would conclude that the tribunal was biased. It is submitted that in the current situation, a fair-minded and informed observer, having considered the facts, would conclude that the arbitrator was biased. Although the aforementioned cases are not in relation to arbitration, there have been several applications to the courts to have arbitrators removed which have followed the same test of impartiality. For example, in Sphere Drake Insurance versus American Reliable Insurance Company, 2004 EWHC, Mr. Justice Cook relied on the same test of impartiality and stated at paragraph 24, the question is whether or not a fair-minded and informed observer would reach the conclusion to which Lord Hope referred to in Porter v. McGill. Whilst it is acknowledged that Mr. Justice Cook did note at paragraph 43 the lack of confidence that any party to the arbitration would have in such an arbitrator is not the determining factor. He proceeded to remove the arbitrator in that case on the basis that a fair-minded observer looking at the matter objectively would conclude that however much the arbitrator in that case tried to put out of his mind his prior conclusions, connections, and knowledge, he would come to the matter with some preformed views which would present a danger of unfairly regarding with favour or disfavour the case of one of the parties concerned. It is also worthy of note that in the case of Laker Airways versus FLS Aerospace Limited, 2001 WLR 113, Rex J at paragraph 117 stated, "Doubts, if justifiable, are sufficient. It is not necessary to prove actual bias." The case of Andrews trading as BA Contractors versus Bradshaw 2000 BLR 6 involved an arbitrator who had framed a letter to one of the parties in the arbitration in irritable terms and was as a result removed by the court. This decision was overturned, however, by the Court of Appeal. The point in mentioning this case is that if the writing of a letter in irritable terms is borderline enough to bring into doubt the impartiality of an arbitrator, then surely the occurrence in the past of a drunken skirmish between the arbitrator and a board member of an affiliated company of the claimant makes the question of lack of impartiality irrefutable. In conclusion, the claimant submits that all three of these matters identified in their own right should give rise to sufficient doubts as to the possible impartiality of the arbitrator as follows. 1. The pre-existing relationship between the arbitrator and the lawyer representing the respondent, together with the lawyer's laudable recommendation of the arbitrator for another matter, must give rise to any fair-minded and informed observer concluding that there was real possibility of the arbitrator in question being biased. 2. Likewise, the fact that the arbitrator had in the past got into a drunken skirmish with a board member of an affiliated company of the claimant must give rise to any fair-minded and informed observer concluding that there was real possibility of the arbitrator in question being biased. Thirdly, the fact that the arbitrator had previously written an article advocating a relaxed approach to the performance of contracts in the amusement industry, which is the very essence of this dispute. Any fair-minded observer looking at the matter objectively would conclude that he would come to the matter with some preformed views which would represent a danger of unfairly regarding with favour or disfavour the case of one or other of the parties concerned. Taking all of the above matters together and following the principle of Mr. Justice Cook in the Sphere Drake insurance case, a fair-minded observer looking at the matters objectively would conclude that however much the arbitrator in that case tried to put out of his mind his prior conclusions, connections, and knowledge, he would come to the matter with some preformed views which would present a danger of unfairly regarding with favour or disfavour the case of one or other of the parties concerned. Article 10.6 of the LCIA rules require the LCA court decide upon the challenge and, if upheld, shall revoke the arbitrator's appointment. The claimant requests that the court uphold their challenge and revoke the arbitrator's appointment accordingly. Article 10.7 allows for the LCIA court to determine whether and in what amount and to whom any party should pay forthwith the costs of the challenge, on the basis that the challenge is valid and should not have been disputed by the respondent, thereby negating the requirement for these proceedings. The claimant requests that the court instruct the respondent to forthwith make payment to the claimant the costs of this challenge. Thank you.